Oh, hi there, folks. Elder Law Care Attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, today's question is it necessary to hire an elder law attorney when you're going into a long-term care facility or skilled nursing facility? Folks, I'm Elder Law Care Attorney Patrick Kelleher, and I am also the author of How to Slay the Metaphorical Four-Headed Beast. How to Slay the Metaphorical Four-Headed Beast of Estate Planning and Elder Law, which is probate court, the estate death tax, financial creditors and predators, and maybe that $15,000 per month nursing home or more in some cases. Is it necessary to hire an elder law attorney when you're going into a skilled nursing facility or a loved one is going into a skilled nursing facility? And from my experience, absolutely yes, folks. You will not want to get on a plane and fly a plane if you are not a licensed, experienced pilot, right? You would not want to do open heart surgery if you did not have a skilled heart surgeon handling the tools to do that heart surgery. The elder law attorney is tantamount along the same level of those other skilled, disciplined practitioners, okay? Because they are experienced with the navigation on how to, number one, apply for and receive Medicaid benefits to help either you or a loved one qualify for Medicaid benefits. So Medicaid can help assist pay for your long-term care in a skilled nursing facility. Also, folks, that skilled, experienced elder law attorney ought to also help you or your family members protect, preserve, and pass on the excess assets that you or your spouse may own when a loved one is going into a skilled nursing facility. Folks, Medicaid and cost of long-term care is very, very complicated and expensive. The statistical data says this: 70% of people 70 and over will need some level of long-term care or assisted living someday. I was recently reviewing an admissions agreement for a client of mine with her son. We're helping the son get his mom on Medicaid benefits to pay for the mom's skilled nursing facility. I like to review the admissions agreement before my client's child signs off on the admissions of my client. This nursing home, I will not disclose any names of the nursing home, but their daily pay rate was $665 per day. That's right, folks. I had to take my calculator out and run the number. $665 per day over 30 days per month. How much was that? Over $19,000 per month. That's right, $19,500 roughly per month. This nursing home is looking for these folks to private pay. Average stay in the nursing home, again, is 3 years. Run the numbers there, folks. That's a big astronomical number. So from my experience, most folks are unable to financially pay private pay, whether it's $15,000 a month or $19,000 per month private pay to a nursing home. So most folks will look to obtain assistance from Medicaid benefits, Medicaid services. In order to qualify for Medicaid services, it'll be in your best interest to have an experienced elder law attorney help you apply for the Medicaid benefits and complete that Medicaid application, because it can be rather daunting and complex. It can take 3 to 6 months, in some cases longer, because the Medicaid caseworker has the right and will likely look at your assets when you apply for Medicaid benefits. They have a right to go back 5 years into your finances to review all your financial criteria. Look at distributions and checks that you are writing. They'll be looking for things like gifts. Were you making any gifts to your children or grandchildren or whomever? Any money spent on anyone other than yourselves, usually for $1,000 or greater, oftentimes will raise a red flag to the Medicaid department. When Medicaid feels or observes or identifies that you've made gifts that were not appropriate, those gifts will be categorized or construed as a penalty period. And then what does that mean? The gifts that you made to children or grandchildren, in order for them to cure those gifts, they typically have to repay those gifts to you in order for the Medicaid department to look at or consider granting or approving you for Medicaid benefits. If not, they have this thing called a penalty divisor. They'll look at what the average cost of the nursing home is. They'll look at the size of the gift. For example, if the nursing home Medicaid pay rate, just for simple numbers, is $5,000 per month, it's often higher. But if it's $5,000 per month and you made a $50,000 gift, they'll run the numbers. $5,000 per month Medicaid pay rate to the nursing home, and you made a $50,000 gift. They'll run the numbers. 5 times 10 is 50 grand. They'll create a penalty period for 10 months. What does that mean? In layman's terms, they'll say, sorry, but you do not qualify for Medicaid benefits for a period of 10 months. Come on back if you cannot cure that penalty. If the recipients of that gift of $50,000 cannot cure that penalty and repay that gift, then you are penalized under the Medicaid rules for a 10-month period. And then come on back after that 10-month period and reapply. If you have a community spouse still living in the community and they're healthy, they're allowed to have certain amount of assets, roughly about $135,000 in change in their names. Anything in excess of that is going to disqualify the nursing home spouse from qualifying for those Medicaid benefits. That's where the skilled elder law attorney will come in handy to help you do permissible spend downs, spend down the estate to the permissible levels, and then in addition to that, help you shelter and protect and preserve any assets that are in excess of that Medicaid threshold number for the community spouse. Also important, a couple of other pro tips here that a lot of folks do not think about. It's helpful for your elder law attorney to be familiar with the Federal Nursing Home Reform Act, the Nursing Home Reform Act, which means when you are applying for Medicaid benefits and Medicaid application is pending, the nursing home cannot discharge you for non-payment. They cannot discharge you for non-payment in a skilled nursing facility so long as your Medicaid application is pending, okay? Also, another really important tip that I'd like to advise clients on, it's important for the elder law attorney to review that admissions agreement. It's important for things like to ensure that your client or your client's child is not guaranteeing payments. They're not a guarantor. They're not guaranteeing payments and so forth if Medicaid does not pay. And there's certain language that nursing homes are permitted to put in there, but there's also other language under the Nursing Home Reform Act that they should not put in there as well. I typically advise our clients never sign those applications or admissions agreements personally. You may want to sign those better off as the fiduciary, as the power of attorney, or in some cases the conservator, or in some states the guardian of the incapacitated person. So that way you are not personally taking on financial responsibility. So be very, very careful about the language in those admissions agreements. Folks, if you found this video helpful, please scroll down, leave a comment, post a question, and a member of our Elder Law Care team will get back to you as soon as possible. If you like more education, pick up a copy of my book on Amazon or go to elderlawcare.com because you will learn how to slay the metaphorical beast of elder law. Thanks for being with us today, folks. Elder Law Care attorney Patrick Kelleher. We'll see you next time.